Good morning. We will listen Young Joon, that is Justice of the Supreme Court of Korea. The lecture is about the dynamic natures of legal interpretation and the role of the judiciary. Thank you for the lecture.
It is indeed my great pleasure and delight to be here today and to be a part of this wonderful conference. My name is Kwon, and as introduced, I'm currently working as a justice in the Supreme Court of Korea. I began my career as a judge, and it was followed by 17 years of my academic career. I was a law professor at Seoul National University for 17 years, and my main field of research was a private law, traditional private law. But I was also interested in the field of intellectual property law. As I was delving into the laws of my interest, I felt the need for theoretical depth and stronger philosophical foundation to better understand the substantive law that I was researching in. So it was at that moment that I turned to my colleagues in my institution who are in the field of legal jurisprudence. And I was edified and inspired by their wisdom and by their insights. So through those momentums, I came to really respect and admire my fellow professors in the field of legal jurisprudence. And I was also able to benefit from a lot of wonderful articles that have been written by legal philosophers around the world. So I feel like I'm dreaming today because I'm in the middle of those esteemed and respected law scholars in the field of legal jurisprudence from around the world. And I really wish that I could benefit more from you in the future. I naturally ask myself what I can do today because I'm by no means an expert in the field of legal philosophy. And I have no intention to propose a new theoretical framework in the area of legal jurisprudence. And I don't have any capacity to do so. Perhaps what I can do today is to share my thoughts and experience and observations based on my career as a judge or as in the position of the Supreme Court justices. And as a justice, I mundanely am involved with dealing with so many different cases. And as I deal with those cases are from different areas of law. Some cases are about private law. Some cases are about criminal law. Some cases are about administrative law, tax law, or even some cases have some constitutional legal issues. And those cases sometimes involve issues of legal interpretation. So I would say, as a justice, I am involved with interpretation of a certain article, be it in the Constitution, be it in the administrative law, or be it in the civil code. So I thought perhaps I could share my experiences as I confront those interpretive issues in various cases. And perhaps it could help you inspire your future research, especially for those who are interested in the field of legal interpretation. So that's what I'm going to do. And in the meanwhile, I will also introduce some of the cases that have recently been handed down by the Supreme Court of Korea, and also the cases that are currently pending in the Supreme Court of Korea. So without further ado, I would proceed to my subject. As I have previously mentioned, I'm going to talk about legal interpretation in practice, not in theory. And in practice, we have very specific and very dynamic array of cases. We often talk about grand theories of legal interpretation. We talk about originalism, we talk about textualism, sometimes we talk about purposivism. Those grand theories are really great. They're a wonderful source of inspiration. They are coherent, and they give us clear reasons why we should interpret such a provision in such a way. But in practice, those grand theories are regarded with a caution in the judiciary, because no single grand theory can account for every aspect of legal interpretation, because interpretation is inherently contingent, it is inherently dynamic, it is inherently context-specific, case-specific. So given those dynamism in legal interpretation, it wouldn't be possible for us to account for every aspect of legal interpretation based on a single theory, be it originalism, be it textualism, or be it purposivism. So I think there are values and limitations of unified interpretive approaches. They are definitely valuable, but there are limitations. There are pros and cons. So I think there is a dynamic nature of legal interpretation, and there are various factors influencing the dynamism of legal interpretation. We can think of individual distinctness of the judges, because judges with different values, with different backgrounds, with different experiences will inevitably be led to a different outcome in legal interpretation. And we can also think about judicial hierarchy. We have 3 instances of the court in Korea, and I think it is basically the same throughout other jurisdictions. We have a district court level, which is court of first instance, and then we have court of appeals, which is the court of second instance, and then the court of last resort, which is the Supreme Court, where I'm working currently. So even though they are dealing with the same article in the same statutory law, the mode and outward appearance of legal interpretation may be different from instance to instance. For example, when we are talking about lower courts, they are more involved with dispute resolution. Even though they're interpreting a specific provision in the specific statute, they are more concerned about a just dispute resolution. But as it goes up all the way to the Supreme Court is more concerned about normative articulation, of setting forth the guideline for future cases. So because of those different functions and the roles of the different instances of courts, even though they are involved with exactly same provision interpretation, they might appear differently. And this could be one of the contributing factors to the dynamism of legal interpretation. And then we can also think about legal domains. For example, legal interpretation in the field of substantive law may be different from the legal interpretation in the field of procedural law. Interpretation in the criminal code might look different from interpretation in the civil code. So if we think about domains of law, different domains of law, I think they are one of the contributing factors to the dynamic features of legal interpretation. We can also think about specific provision characteristics. Some provisions are more specific, they are newer, and they have more clear legislative intent, while some provisions are more archaic, they are old, they are more general, they are more abstract, and it's very hard to figure out clear legislative intent embedded in that provision. So those traits and properties and characteristics of each article may exert some influence on the outcome of legal interpretation. So this is one of the contributing factors. And also we can think about the relationship with legislature. Relationship between the judiciary and legislature might be different from jurisdiction to jurisdiction. For example, in autocratic countries, maybe legislatures are not functioning well. Whereas we can think of more developed democratic countries where legislature is doing its job just greatly. So given this dynamism, we easily can conclude that the interpretation might look different from jurisdiction to jurisdiction based on the relationship between legislature and the judiciary, which is inherently dynamic and perpetually evolving. We can also think about relationship with administrative agencies. For example, there has been a traditional doctrine which is called Chevron doctrine in the US. And for those who do not know the Chevron doctrine, this is about deferring to legal interpretation done by administrative agencies. So when federal agencies interpret a specific provision in a certain way, then there is doctrine called Chevron doctrine, which will force the judiciary to respect the previous interpretations that have been done by the other administrative agencies. And that had a huge and immense effect on the landscape of the legal interpretation. But 2 weeks ago, this doctrine was discarded by the US Supreme Court. There's no longer Chevron doctrine. This means there's a new relationship between the administrative agency and the judiciary. And this will surely impact the outcome of legal interpretation. Also, timing of interpretation. What is deemed just at one time would be deemed unjust in another time. And that's why sometimes case law is changed. Judicial precedents are overturned by the Supreme Court itself, because once just case law does not remain just as of now. So that's why the Supreme Court will sometimes overturn their own rules. Of course, there are different attitudes toward overturning the judicial precedent. For example, some Supreme Court justices will be hesitant to turn over the prior precedents, whereas some justices are more progressive and they're more proactive in repealing the judicial precedents. Those different attitudes will affect legal interpretation. We can also think about comparative law consideration. There are jurisdictions which are friendly to comparative research. For example, in the case of Korea, a lot of law scholars are very much friendly to this comparative research, so that they look to other jurisdictions to see what kind of legal systems they have, what kind of legal provisions they have, how they interpret those provisions. And those comparative considerations actually exert a certain degree of influence on interpreting our own provisions in our domestic jurisdiction. But there are some jurisdictions where they are indifferent to foreign jurisdictions. They will never look at how foreign jurisdictions are doing in terms of legal interpretation. So these differences can also lead to the different outcome in legal interpretation. So I have just listed some of the factors that might contribute to the dynamic aspect of legal interpretation. There are just some of them. I think there are a lot of them which are not listed here that would ultimately contribute to the dynamic aspect of legal interpretation. But what I'm trying to say up to now is that it is dynamic, at least from the practitioner's point of view. And we should accept it as a reality and start from there and see what kind of theoretical frameworks we can provide to those existing realities. So I would say there's bounded flexibility. It's like a ship that is linked to an anchor in the seabed. Just think of the seabed. There's an anchor, and there's a chain, and there's a ship on the surface of the sea. It cannot drift away because of the anchor, but it still can move within a certain limit. And I think that kind of describes how legal interpretation is done in realities. We do have an anchor, for example, text. We cannot escape from the text of the law, but still we can move around within a certain ambit, within a reasonable scope. So there's flexibility in legal interpretation, and these flexibilities are influenced by dynamic aspects. So what I'm going to do today is just to share my observation on some of those factors, primarily about as to who interprets individual disputes of judges, and then what is being interpreted, which is about domain of law and provisions that are being interpreted. And finally, a relationship between judiciary and the legislature. So those are 3 factors that I'm going to share my observations. And I hope that it could lead to some kind of theoretical implication for our future research. So let me now walk you through the issue of who interprets. I have already mentioned there are some roles of judges to be played in the realm of legal interpretation. So there are some impact of the individual needs or individuality of the judges on the outcome of legal interpretation. Maybe this is not true when it comes to easy or ordinary cases. Regardless of who sits as a judge, the outcome will be the same. So it doesn't really matter who sits at the bench, because there are a lot of established legal doctrines regarding legal interpretation. So no reasonable judge will depart from those established doctrines. And most of the cases are about fact-finding or about mere application of the firmly and solidly established legal doctrines on a certain provision of a certain statutory law. So when they apply those established doctrines, the outcome will be the same. So in most of the cases, individuality of the judges do not matter. That would be the practical reality. But at the same time, if we think of a relatively few number of hard cases where there's no judicial precedent, where there are judicial precedents that are conflicting with each other, where there are some judicial precedents that are vague and abstract, so we do not really know the exact meaning of those judicial precedents. In such scenes, we find some kind of a individual needs of individual judges playing a certain role. Of course, a number of hard cases is very small in number. I don't know the exact percentage. Maybe it would be less than 1%, let's say. Maybe 99% of the cases are just easy and normal cases. And hard cases are perhaps less than 1%. But qualitatively speaking, this very few number of hard cases will greatly impact the entire landscape of entire legal system, entire legal order, and entire feature of legal interpretation. So although quantitatively it's very few in number, but qualitatively speaking, it will have a great influence. So that's why hard cases matter. And in those hard cases, individual judges will play a certain role. Based on my short experiences and observations, I think there are two processes of judicial decision-making. Let's say there's a first phase, which I would call intuitive step. And there's a second process, which I will call deliberative process. You accept the case, and then you read through those case records. You know who the parties are, you know what the legal issues are, and you basically know the legal doctrines that are applicable to this case. And then you have your first intuition as to the outcome of the case. You perhaps know somehow that the plaintiff should win in this case, or conversely, the defendant should win in this case. This is just your tentative conclusion after your first examination of the case. And I will call that a tentative conclusion. And then you are guided into the second phase of the interpretation, which is the deliberative process. You look at the case more deeply, and you look at the judicial precedents in more depth. You look at the relevant academic articles to delve into the issues. And then you have a conversation with your colleague judges. You have official deliberation on the case. And through this process, your initial conclusion might change, which is desirable. But my candid observation is it is more likely that they will stick to initial conclusion that has been drawn out in the initial step. I don't know why, and I want to know why. I sometimes reverse engineer my own decision making. Maybe someone would say judges are too proud to change their initial conclusion. They probably think it's a shame to change their conclusion. But it is not always necessarily so, because a lot of times those initial conclusions are just in your heart. They are not disclosed to your colleagues. So you can freely change your conclusion. But you don't do that usually. And I want to know why. And my observation is that sometimes, even though we call it intuition, it is actually a very mechanical, meticulous, articulate process that is going within yourself based on your professional experiences, based on your professional knowledge. You think you have reached an intuition, but actually inside you, perhaps something very mechanical was going on in a matter of seconds. And then you call that your tentative conclusion. But it was actually based on your professional experiences and professional knowledges. That could be one reason. And another reason is that because your initial conclusion is firmly rooted in your personal experience and background. So because you cannot easily change your personal value or personal background, you will not easily change your initial conclusion, especially so in the case of hard cases, because it is deeply rooted in your personal value. So it could be your personal value, your personal experiences, your personal educational background, even your personal encounter with a fellow scholars recently that could have influenced your outcome. But whatever they are, what I'm trying to say is that they are individual, they are distinct, and they do influence the outcome of legal interpretation. So it's very important that you collaborate with other people because you can always be biased. You may have some personal preference and inclination, but there's no guarantee that it is correct and true. You cannot easily change your initial impression or intuition, but just humbling yourself and carefully listening to your colleagues and carefully reading articles to other effects, you probably can change your conclusion. And this is why I think legal interpretation is kind of collaborative act, it's collective act with your colleagues. And sometimes you compromise your conclusion despite your personal value system. For example, in a recent case that was handled by the Supreme Court of Korea, there's case what I would label as green paint case. This is cases about two young environmental activists. They were not happy about one certain Korean company called Doosan. It was a big conglomerate company. And Doosan was having a plan to build a coal power plant in Vietnam. And as you might be aware, this could endanger the Earth in terms of global warming. So these environmental activists were unhappy about this decision to build a coal power plant in Vietnam. And they planned a demonstration in front of headquarters building of Doosan. What they did was to carry green spray, and there was a beautiful logo made of marble in front of the headquarters building. And then they sprayed green paint on the logo of that company. And then they began chanting their slogans, speaking what they want to speak about environmental protection. But interesting thing was they were also preparing a washing tool to wash out the green paint once their demonstration is over. But they were arrested by the police as they were washing the logo covered with green paint. They were charged with crime of property damage under Korean criminal code. In the first instance court and the second instance court found them guilty. It was actually a damage of property is what they found. And this case came to Supreme Court. And there were deliberations among justices. And the defendant of this case were not concerned about them being punished, but they wanted to set some kind of judicial precedent about a special exception of free speech to environmental protection-related demonstrations. This is a huge issue. Environmental protection is a huge issue. Free speech is a huge issue. And giving some exception to environmental-related demonstration is a huge issue. And you can easily imagine that there could be different viewpoints even among the justices. But the outcome of the case was that it was not a property damage. They evaded this grand issue by compromising to say that this did not amount to the damage of the property because it was washable, and actually they were trying to wash out the green paint, and this would not constitute property damage under Korean criminal code. So sometimes they compromise with each other to evade the huge issue of value conflicting situations. So from those experiences, I think the composition of the Supreme Court is very important. Diversity matters, so it's very important to have justices from diverse backgrounds, diverse gender, educational background, professional backgrounds, but they are limited. For example, in the case of Korea, we have 13 justices. So with this limited number of justices, it is nearly impossible to represent every walk of life in this country. And even so, they tend to have similar professional background. So there's inherent limitations as to achieving diversity in terms of the composition of the Supreme Court. So what I think what matters more is perhaps a procedural law, the procedure where diverse voices can be heard in an open manner, and diverse information can flow into the process so that they can be considered by the judges. So it is all about procedure. They first come from the parties, diverse parties with different interests. They come from diverse councils, but they can also come from third parties. For example, in the Supreme Court of many jurisdictions, they have a system called amicus curiae brief. These are systems about hearing opinions from third parties who are indifferent to the outcome of this specific case, but who are having some kind of theoretical interest or business interest. So they would submit their opinions to the Supreme Court, and they will be considered by the Supreme Court. I think this is good because diversity in the composition of the Supreme Court has its own limits. But there's no limit as to how we can gather diverse information and perspectives from different walks of life. So procedural aspect is very important in legal interpretation, and also open-mindedness of individual judges. If judges are too much prejudiced, if they're too stubborn, even though there are diverse information and perspectives flowing into the procedure, they would not listen to them, and they would not be reflected in the legal interpretation, and that would be a disaster. So I think procedural aspects and open-mindedness of individual judges are very important. And I think there are some kind of theoretical tension that may be needed because of the reality that in a relatively few number of hard cases, judges will exert certain influence on the outcome of legal interpretation. That calls for theoretical tension for researching in the individual needs of the judges. And I believe that they are already done in the form of different branches of legal jurisprudence. For example, legal realism, it is about finding out how courts make a certain decision making. And I know of some social science related branches of legal jurisprudence where they try to find out a specific realistic factors that actually influence the outcome of legal interpretation, which I think is very good because that's practical reality and that should be taken into theoretical consideration. Now, my second topic is about what is being interpreted. There are diverse approaches to legal interpretation. There are universal and general rules for legal interpretation. But I think there are some local rules, parochial rules, that are more customized, that are more applicable to each branch of law. That's what I would call compartmentalization of legal interpretive rules. So for example, the interpretation in the realm of constitution might be quite different from interpreting a tax law provisions, which are very technical, which are very detailed. If you think of constitution, it is laden with values. We talk about free speech, we talk about freedom of religion, we talk about due process, but actually those articles in the Constitution do not give us a detailed guideline as to how we should interpret those provisions. So there are a lot of value that are put into the interpretive processes. For example, current Korean Supreme Court deals with a freedom of religion related case. It has not been handed down yet. It's about COVID-19 and church closure. You might be aware of those cases happening among different jurisdictions. A lot of cases were solved in the form of preliminary injunctions, so they are all over. Several years have passed. We are all over with pandemic, but still there's a case on the merit that still awaits the decision of the Supreme Court. And this case is about closing the church for 2 weeks. The in-person worship service was banned for 2 weeks. Prior to that decision by the administrative agency, they were able to participate in the worship service, albeit in a limited manner. Limited number of people could participate in the worship service. But as the COVID grew more serious, they made a decision to close down the church for worship service tentatively. And they brought the lawsuit. They didn't like this decision. This is now pending under Korean Supreme Court. And this requires so much consideration of value, especially a value that is put into public health right, value that is put into freedom of religion. And Constitution does not really provide us with detailed guidelines as to who should win. So this will inevitably invite the values of a personal Supreme Court justices. To name another example, interpretation in the civil code might look different from interpretation in the criminal code. Since I was more into civil law field of law for many years, let me elaborate on the interpretation of the civil code. First of all, I would like to make an interesting point that civil law scholars do not talk much about interpretation of the articles of the civil code. It was my case as well. And I don't know why, but I realized that we did not talk much about legal interpretation until I became Supreme Court Justice. Because we always talk about legal interpretation in other areas of law, especially in the areas of criminal code, in the areas of administrative law or tax law. But we rarely talked about interpretation of the text of a certain provision in the civil code. So I was intrigued by this point. Why is it so different? Why do we not talk about legal interpretation in the civil code? And I think maybe that has to do with the characteristic and history of the civil code. Before proceeding, I know some of you are from common law jurisdictions. Korea is based on civil law tradition. So we have a statutory law called a civil code. And I know that there are a lot of jurisdictions who have a civil code as well. But I also know that there are jurisdictions where they do not have a civil code in the traditional private law area. Instead, they rely on case law, judicial precedents. But I think the essence is the same. We are all involved with interpretive action. In Korea, we interpret the text of the provision. In common law jurisdictions, they also need to interpret the prior judicial precedents, which are in the form of a text. They have to find out the meaning and the scope of the judicial precedent. So after all, we are all involved with interpretation. So I think there are several factors that characterize civil code. For example, civil code, at least as far as Korean civil code is concerned, is very old law. It's not old in the sense that it was enacted in 1960. And it was amended several times, especially in the field of family law. So we have a relatively newer provisions in the area of family law. But when it comes to a traditional private law, such as contract law, property law, or tort law, it stays as it is when it was first enacted back in 1960. And this civil code also traces back to a classical civil codes of different jurisdictions, and most notably jurisdictions in the European countries, such as German civil code, or Austrian civil code, French civil code, or Japanese civil code, which were influenced by those jurisdictions. And we know that it even traces back to Roman tradition. So in centuries, civil law has developed over time, and it withstood the time. It was verified and tested with all kinds of circumstances and contingencies. And the remaining survivors now exist in the form of the civil code. That's why principles embedded in the civil code are very generic, very, very universal, and very archaic. So you cannot find clear legislative intent because you don't know who the legislators are, because it is a core work of centuries of different scholars, of different jurists in different jurisdictions. And it is general, and it is also universal. Civil code is perhaps one of the areas of law where comparative research is extensively done. That was my case as well. I had to look at many different jurisdictions, many different civil codes, and many different interpretations in order to draw a conclusion on a certain interpretive point in the Korean civil code. So I think that's a common feature of the civil law scholars. So I think those kind of features influence the appearance of interpretation in the civil code. So we have a lot of scholarly opinions. We have a lot of judicial opinions. So I think that is why we look at commentaries or jurisprudence before looking at the civil code articles. It is a shame to speak, but even as a civil scholar, I did not look at the article or text of the civil code, but I would look at the commentary or the judicial precedent first to figure out the meaning of law. That's quite different from when I look at the text law articles or administrative law articles to find out what the law is. So I think there's a stronger influence of the judiciary and stronger influence of legal academia, and they are dominating the interpretation of articles in the civil code. And in that sense, it's very flexible and it's very dynamic and it's very global. But when you think of criminal code, you have a different feature. For example, you might know nulla poena sine lege, which is no punishment without law. This is kind of cornerstone of criminal code. And this is embedded in our heart. This is embedded in our practice. And this leads to textual emphasis. We emphasize about the strict interpretation of the article. We would not depart from the text. And analogical interpretation or analogical application of a certain provision will strictly be prohibited. And the embedded idea is that we should protect the rights of the defendant. So for example, an analogy can be applied when it is in favor of defendant's right, but in disfavor of defendant's right, it is inconceivable. So text plays a much, much greater role in interpreting criminal code. So as I have previously mentioned, there are varying interpretive methods across different domains of law. And I think different areas of law require different approaches of interpretation. Maybe common ground will exist, but there will be some local rules that are more customized, more tailored to each domain of law. And I think that's why we need the interaction between legal theories and each substantive law. And from person's perspective, that's why we need collaboration between a general legal theorists and specific substantive law experts. Maybe that's why we need a collaboration between legal theorists and practitioners like myself, because we need more meticulous, more detailed, more tailored, more nuanced approaches to each domain of law. And now to my final point, which is boundary of legal interpretation. What I'm trying to say is a legal interpretation from the perspective of the relationship between legislature and the judiciary. And I think judiciary is a prudent steward. We have a constitution, and judicial power comes from the constitution. Constitution was made by the people, at least theoretically, but also in practice, because it has to be ratified by the people. And then there are many statutory laws that are made by people, to be more exact, made by the representatives of the people. So what we have as a judicial power comes from the people, comes from the Constitution, comes from the legislative power. You probably know the movie Spider-Man, and there's a very famous wording that comes out of that movie that I think it's about if you have a stronger power, you have more responsibilities. So power comes with responsibility. So we have a very powerful judicial power as a judiciary. When we declare what the law is, it is law. So it's really powerful authority that we possess as a judiciary. But power comes with responsibility. And as a matter of fact, we don't become liable for the decisions that we make as a Supreme Court justice. For example, those who are working for administrative agencies, they might at least face a political accountability or responsibility against people. They might be fired. They might have to issue an apology to the people. and perhaps prime minister has to step down if they have done something wrong in the context of their policies. But we don't step down because our decisions were wrong. We don't really bear legal responsibilities. Well, we can be impeached under our constitution, but it has never happened in the history of Korea. So there's scant liability, and there's a great power of the judiciary. And there's kind of imbalance between the power and responsibility. Then what justifies this gap between this enormous power and scant responsibility? First, I think that is independence of the judiciary. If we have to bear so much liability because of the decisions we make, then that will undermine and hamper the independence of the judiciary, which will in turn harm people in the end. So I think that could be one justification why we possess much power, but with less responsibility. And the second justification is perhaps the trust given either by the Constitution or by the people that the judiciary itself will self-monitor and restrain the overstepping of its own power. So we don't really bear responsibilities, but we are required to look at ourselves and to see if we are overstepping the constitutional limitations that have been set by the Constitution. Of course, within the ambit of our power, sometimes we need to be progressive and proactive. We can proactively interpret the provisions within the ambit of our power. But once we go out of the boundary, we should be very, very prudent, because we will not be held accountable for what we do, what we declare as law. But we will be betraying a constitutional trust or trust by the people that judiciary will be honest in exercising its own judicial authority. So I think judiciary should act as a prudent steward in that respect. And I think there are various elements that might define the relationship between the legislature and the judiciary. For example, think of text, think of legislative intent. They are usually the factors that might fortify the legislative power, legislative supremacy. So emphasizing those factors might lead to a more respect for the legislature in the legal interpretation. But if you emphasize coherence of law or purpose of law or even the consequence of a certain legal interpretation, then you might be leaning toward more judicial power. So we have dynamic factors, but based on what kind of factors you're emphasizing, you're either leaning toward legislative supremacy or judicial supremacy. So let me just mention some of those factors. First, text. We all know that text is very important. It's theoretically important, it's practically important, but we also know that there's a limitation to text, because hard cases are usually cases about obscure, ambiguous, and abstract texts. And even just by looking at the text, we do not know what the outcome is. So we have to look at other factors. And I have talked about a text should be strictly interpreted in the area of criminal code. And let me just mention some of the cases that were handed down recently by the Supreme Court of Korea. First case is about determining the meaning of detention. So in Korea, when you are put at criminal procedure, you are either detained, or you can be without detention. When you are detained, there's a system called mandatory public defender system. So when you're in custody, state will provide you with a public attorney, public defender, in a mandatory way. That's what criminal procedure code says. Now, the meaning of the detention was at issue of this case. And the prior case law was saying that this detention means the detention of the case that is now at trial. So if you're detained because of the robbery and you are now tried on that charge, that is detention. But if you have already been detained by other charges, but at a different trial, let's say a rape, you are technically not in detention because of that case. So only the formal will be the ground for mandatory public defender. But it was overturned by the court because the underlying rationale was regardless of the cause of the detention, what really matters from the perspective of the purpose of the public defender system is the state of detention. You don't really ask about why you were detained, but the state of the detention is what suffices for public defender system. So that is one of the examples where text was broadened from the perspective of the purpose of public defender system, which was at issue in this case. And there was another case about carry. You know what carry is. For example, I'm carrying my cell phone now. This is in my pocket. Under Korean Criminal Code and special legislations, if you're carrying a weapon when you're threatening or when you're assaulting other people, then you face aggravated punishment because of the aggravated danger. So in this case, the meaning of carry was at issue. In this case, what was at issue was a knife in the kitchen. It is obviously a dangerous weapon. But it was about domestic violence between husband and wife, and husband was beating wife for 4.5 hours at nighttime in a very small studio. And the knife was not in the place where it was supposed to be. It was supposed to be in the kitchen, but it was found on the table, which was very close to the defendant, who was beating the husband beating his wife. Why it was on the table was at issue. There were different statements from the wife and from the husband. It was found out that once husband held his knife, but husband said, it was just for another purpose. It has nothing to do with threatening or beating my wife. But even accepting his statement, it was true that it was put very close to husband as he was beating his wife. So the meaning of carry was at issue. And there was position alleging that because husband was not holding this knife in his hand, he was not carrying a weapon. And this is in line with strict interpretation in the criminal code. And there was another position that even though he was not holding onto the knife, it was very close to husband, and it was always possible for husband to reach out to the knife and use it for a crime. And he actually disclosed his intention to use this weapon at any time as he was threatening and assaulting his wife. And the Supreme Court case said it is within the meaning of carry. This is within the textual boundary of the possible meaning of carry. So sometimes, even though there is a strict interpretation theory in the criminal code, we will look at the text and try to broaden the text to a possible scope. We can also think of legislative intent, and they actually exercise different roles in different contexts. Sometimes finding legislative intent is very, very difficult, especially when we lack legislative materials that show what the legislative intent was. And even with the legislative materials, it sometimes collide with each other, sometimes not clear enough. So it is very easy to manipulation of the judges. Judges may declare that legislative intent was so and so, but maybe it was not so. So it's very vulnerable to manipulation of the judges. But even given those limitations, I think legislative intention is very, very important. But there is a case where legislative intent is unclear, or even in the case where legislative intent was absent at the time of the legislation. We are in limbo. We don't know where to go. For example, in 2006, there was a seminal Supreme Court case about transgender person. So the case follows as this. There was transgender person who became male from female. He went through transgender operation. And outward appearance is male. But in the family register, he's registered as a female. It was registered at the time of his birth. So because of this family register, all these social securities or identifications are saying that he is female, despite his outward appearance, despite his actual sexual orientation, despite his mode of his lifestyle. So this would be a grave infringement upon his fundamental right. So he wanted to change his gender from female to male to fit the reality. But the first and second instance court said no, because it has to have a statutory ground, and that there was a Family Register Act that allowed correction of the erroneous entry. You can erroneously enter your gender incorrectly, or your birth date incorrectly, name of your father or mother incorrectly, but it was an error at the time of entry into family register. But we are talking about ex post circumstance of change of circumstance that has happened after the entry of family register. So the court said this does not fit into this legal ground, so we cannot change your gender from female to male because we have no legal ground. But the Supreme Court said it can be broadened to incorporate ex post change of circumstance. I don't know if it is legal interpretation or if it is a judicial legislation, but I think this can be justified because leaving his gender as female would mean grave infringement upon his fundamental right. And there was no legislative movement to correct this. So maybe it was urgent. Maybe it was out of notion of justice. It was inevitable for a judge to step in and to declare very boldly that this includes this circumstance. So sometimes when legislative intent is unclear, we will witness more judicial power in legal interpretation. And finally, purpose. We all know that purpose of law is very important. It has potential benefits, and it also has pitfalls. And we also know there are multifaceted nature of purpose. There may be purpose about the entire law, even the purpose of entire legal system. But we may have a specific purpose for specific provision. I will not go deeper into the asset confiscation case, which is now pending on the Supreme Court. Maybe it will be sufficient to say that this is a case about colliding between the purpose of law and purpose of a specific provision. The purpose of law, which is at issue in this case, was about restoring historical justice. This is about pro-Japanese collaborators and about confiscation of their assets. We were colony of Japan for 36 years. And after being liberated from the colonization, there was a special act which was to correct the historical wrongs, to punish those collaborators. And there were some provisions which were provided to confiscate their assets as a result of their collaboration. So obviously, the purpose of law is to correct historical wrongs. But there was a specific addendum provision to the main body of law, which were talking about respecting the case where judicial precedent, where decision has already been rendered by the judge. So this is about legal certainty of those people who have already received decisions that they are not pro-Japanese collaborators. So there are conflicts between these different purposes of law, and this has become an issue of this case. So I would like to mention that there are multifaceted natures of purpose. And finally, I would like to also address the civil union case, which is also pending on the Korean Supreme Court, which is drawing attention of the general public. Maybe it would be worthwhile to present you with several background facts. In the first place, we don't recognize same-sex marriage in Korea. There were some attempts legislatively to recognize same-sex marriage or even civil unions, but they were in vain. So as of now, we don't recognize same-sex marriage or civil union. So that would be the initial fact that you need to take into consideration. And the second is about Korea National Health Insurance System. We have a public insurance system, and this is a very good system. Every citizen is covered this public health insurance system. Of course, in principle, you have to pay premiums, but this premium is based on your wealth. So if you're wealthy, you have to pay very high premium. If you're poor, you don't have to pay high expenses. Sometimes you're even exempted from having to pay premiums. And then there are a system called dependent system. So let's say there's an employer and employee. An employee is a subscriber to national health insurance system, and his or her dependents do not have to pay insurance premium in order to be covered by the insurance system. And the representative type of this dependent is a spouse. If you're a spouse to an employee who is paying premium to the national health insurance system, spouse doesn't have to pay premium. So that's what we call dependent. And the issue here is whether or not a same-sex partner can be interpreted to be in the category of a spouse. This is a challenging question. And third fact is that we have a constitutional court which deals with declaring unconstitutionality of a certain legislation. So if a certain legislation is in violation of equal protection, the orthodox way of solving this dispute is to take this legislation to the constitutional court and to see if it is constitutional or not. So given these facts, now we have a case. We have a case where a same-sex partner brought a lawsuit claiming that he is a spouse to another he who is an employee. And the first and second instance court say no, because according to current legal order and legal provisions, it defines spouse to be a relationship between heterogeneous sexes, genders. Because these couples do not fall into this category, they will have to pay premiums to be covered by the insurance system. So that was the decision made by the first and second, I'm sorry, that was the decision made by the first instance court, but the second instance court said, although we cannot interpret the spouse to include the notion of same-sex partnership, it is in violation of equal protection clause in the Constitution. So the measure taken by the national insurance system was wrong. So this is now currently adjudicated by the Supreme Court of Korea. And this is another case where the topic of boundary of legal interpretation will matter upfront. So I think it's time to conclude my presentation. Before conclusion, but let me very briefly mention the importance of reasoning and duty of candor. When we decide, we have reasons, but sometimes we don't spell out the reasons why we have reached a certain interpretive outcomes. It is okay if there is established legal doctrines. It is okay if they are all about fact findings or just applying the legal doctrines that are firmly established. But if there's no judicial precedent, if there's some guidelines needed by the Supreme Court, I think we need to specify and spell out the reasonings underlying a specific outcome of legal interpretation. This is especially important because this could enhance understandability and accessibility of the general public to the Supreme Court cases, which will reduce the future disputes. And this will also enhance a dialectic discourse between the academia and the judiciary. Because without knowing the underlying reasonings, there's no criticism. If there's no criticism, then there's no progress of law. So I think, in some sense, we can think about legal obligation of the judiciary to spell out the reasons. Not only the conclusion, but also the reasons. It is different from res judicata effect, which only affect the conclusion. But we are talking about a broader theme of defining and formulating law. And reasons do play a great role. So I think there are a lot of things to be done in terms of interplay between practical realities and insights. And I think they can both complement theoretical research in the field of legal interpretation. As you might imagine, legal interpretation is a synthesizing art rather than a mechanical axiom. And this involves so many variants, so many dynamic factors into consideration. And because legal interpretation in reality is dynamic, I think it is a very, very important that we work together, because perhaps we as practitioners can provide them with more lively materials upon which you can conduct your research. Maybe we can benefit constantly from your theoretical research to find out a possible implication on the specific interpretive issues that we daily encounter in our daily lives. Legal interpretation is both static and dynamic. It should be stable, but it should also be evolving. There should be evolution of law in the form of legal interpretation. So I think balancing between these two different aspects of legal interpretation is highly, highly important. It's like akin to a midfielder's role. We know that Copa America is now going on. Euro 2024 is going on. I'm a big fan of soccer. I'm a big fan of football, I would say. And just think of midfielder. They all have their positions. So midfielder will usually stay around in the middle field of the pitch. But even though their ambit is predetermined, they will constantly move here and there depending on the movement of their fellow players. So if they're all attacking, probably you can participate in attack, but perhaps you may need to step back to fortify the defending system of your team. So interpretation is like this. Judiciary is like a midfielder. You look at various factors. You look at the relationship with legislative branch, administrative branch, and to constantly find out what your proper role is in that very specific circumstance and context. Therefore, sound legal interpretation is indispensable for evolving and preserving the rule of law. And as I have mentioned so far, I think the judiciary can and should play a meaningful role in this process. And there are a lot of roles to be played by you in the legal academia that could ultimately affect our interpretive processes. I'm actually benefiting much from your researches, and I hope to do so in the future. But I also hope that practitioners like myself can offer something to be taken into consideration in your future research. So that concludes my presentation. Thank you very much for your patience. Thank you.